Gunther Teubner, professor of legal theory at Frankfurt, today emeritus professor, but also a truly global scholar, not just a scholar of global law, a scholar who travels across continents, who has experience from different legal cultures, different academic cultures, and who contributed to socio-legal studies probably like very few people in the last several decades. I should say that when I was thinking about our conference on societal constitutions in transnational regimes here in Cardiff later today, I was thinking that, Gunther, you actually liberated sociologists of law from their feeling of being outsiders inside a legal discipline, that who nevertheless felt that they have a special insight into legal doctrine. And you proved that sociology of law can have a profound meaning for general legal science and general legal theory. You liberated constitutional theorists by...
We should not exaggerate.
Oh, we should exaggerate by basically taking the concept of constitution beyond the juridical domain. And with your theory of global law, you successfully have shaken a typical view of globalization as unification or integration, and by pushing into thinking of globalization as fragmentation, hybridization, and differentiation. So it's our great privilege to welcome you here into our socio-legal conversations, and I would like to start by asking you a personal question. You're a war child, born in 1944, growing up in post-war Germany, post-war Europe, and what brought you into legal science and then in particular to sociology of law?
Yeah, I think it is my interest in closed social system, which indeed had to do with the Eastern European experience of my childhood. I could tell you a little story. When I was 12, in 1956, there was the Budapest Revolt against the Soviet occupation, and we were eagerly listening to the Western radio about the reports of that. And then I went to school where the real socialism was active and all that. The official ideology was there. And the teachers told us, watch out, children, this is the American rollback. American imperialism is going to capture the socialist countries. Okay, I listened, and then I went to the church, which was in those days the only one place in the GDR where you could have free political speech. And they told us, listen, children, this is a sign of God against the godless communists. I said, okay. And then I went to the butcher in one dark corner of my little town, and I know he was an old Nazi. And he said to me, Gunther, watch out, this is day X, Adolf is coming back. So I experienced, closed meaning systems and how difficult and even dangerous it was to cross boundaries. So I learned this lesson, and I think there are quite some or shall I say, influences of this Eastern German real socialism past. For example, my skepticism toward etatist reforms and measures and all that, and my preference for civil society. Yeah, and then I went to the West and made my decision to study law. And in school I had more interest in natural sciences and in theory of physics. I wanted to go there, but then I said, okay, law, but not law in itself, not dry positive law, rather And this was, in a sense, due to the Nazi experience of lawyers in those days, where they really had perverted the legal order and it stuck to a kind of Nazi positivism, just obeying Hitler's commands, in a sense, right? So I thought, yes, we need a kind of Gesamtkunstwerk, we need law, but this must be illuminated by philosophy and by sociology in order to know what the good values are and what the society is about. So I decided, okay, I want to study this Gesamtkunstwerk, which was, of course, in a sense, naive. I learned rather soon that the world does not work this way. But nevertheless, I followed this path more or less. And my first experience was doctrine, legal doctrine of the highest level. And I must say, in spite of all my sociological stuff, I have high respect for good legal doctrine, which in England and America is not so well understood with a case law culture, but the European culture with this development of legal dogmatics over 2,000 years, I think this is a high cultural achievement, and this is a conceptual edifice, an architecture with principles, rules, concepts, which is admirable, right? And has a strong philosophical background, also sociological background. But what it's in need of renovation, and here's the very problem. So, and I just loved, to play these games of legal doctrine. But then I came to Berkeley, and this was a kind of wake up, because this was Berkeley in the 70s, after '68 revolution, and it was still vibrant over there. And what I was learning there especially was I got rid of the monastery science style which we have in Europe. You sit in your room and write your stuff and then present it to the colleagues. Please admire, right? Yeah. Well, there you had this kind of unleashed discussion culture, which I really enjoyed. These wild and passionate discussions, which I had there. So, and there was, in a sense, Philip Selznick, who became my tutor, in a sense, because of my teacher, because of his ability to unite sociology of law, and law itself.
Yes.
So his way of having messages, sociological message for law, with his normative sociology, I was very much impressed.
It's fascinating to listen to you and your early experience, because I think it's an experience for a number of sociologists of law in East Bloc. You engage with sociology simply to criticize the formalist, legalist doctrine of the totalitarian state, exactly. And at the same time to understand law as a social phenomenon. And this is one stream. The other stream is this science as a vocation, to put it in Webrian terms. And so from science as a vocation to science as a contestation. And the Berkeley environment was probably very important to you, wasn't it? Because rereading your early article on substantive and reflexive elements in law, which you wrote in those days, it's a fascinating encounter of discourse theory and early systems theory, reconciling Habermas and Luhmann by revisiting Selznick's and Nonnet's concept of responsive law. So, how did you arrive at this notion of...
Well, I accept this. There's a dose of eclecticism in this article.
It's a great article. It's still...
I agree. But, I felt... I wrote this article in a very specific, shall I say, political situation. This was the early 80s, and the time of the great social reforms came to an end, crisis of the welfare state, the failures of the regulatory state, this was all present. And at the same time, there was a strong move of Reagan-Thatcher, deregulation, neoliberal wave, together with the support of sophisticated theory, economic analysis of law moved in, right? And what did sociology of law had to offer? Two things, but they were in a way strange. One thing was empiricism. There were the confessing empiricists in these days who had, really their distance against grand theory. They had almost a contempt for that, middle-range theory at best, and they were, in the data gathering, in a sense, connected to the grand reform project, the governmental data for how do the reforms work and all that. I'm simplifying. On the other side, you had theory. People love theories, doing good theory, but this was the consequence of '68, critical legal studies. And I admire these people. They were erudite. They had taken on in a very eclectic way, everything from Marxism to existentialism, and made, a big mixture out of it. But I mean, they were caught in their trashing attitude. Nothing but trashing. Law was just a facade, and everything was reduced to power on political processes. So, and they had nothing to offer as a kind of counter project, against the neoliberal deregulation project. So this was the situation, and here I thought, yeah, well, I mean, Europe has something to offer in terms of the continuation of the grand theories. So Weber, Durkheim, and all this stuff, and there were our great heroes, Habermas, Luhmann, and then on the other side, Selznick, Nonet, and I brought them together, but also in mind, not only to help theory to have its say again, but also to do something on this, let's call it the political side of it. And this was then the idea of reflexive law as an alternative to, on the one side, command and control regulation, and on the other side, neoliberal total deregulation, this kind of indirect steering of society. And there I tried to, in a sense, to find a way beyond the three. Selznick, Nonet, for me, they were too much still stuck to the social welfare state reforms.
Yeah. Almost your critique of Selznick, Nonet was along Habermas's line. Yeah, if you mustn't overburden the state with social expectations. And,
quite right. Although the responsive law is very ambivalent, and I liked the other side, but I think it was too much attached to the state interventionism. Let's call it like this. Well, on the Luhmann side. I was fascinated by this theory. I think this is the best social theory developed in our times, and I just liked it. And I thought, well, this is not only a great intellectual achievement, but it also reflects really our new realities. But I mean, there was a great deficit in terms of normativity and democracy in it, which again I found then in Habermas. But Habermas for me was in a sense too simplistic, or should I even say totalitarian, in his discourse morality, which he tried to cover every field of society.
Okay. Yeah.
And there was a beginning of societal constitutionalism in this whole thing. The democratization of the different social fields as one of the best demands of the '68 movements. I think this is what they said. This was a great message. Democracy doesn't make sense if it's limited to the political system. We need to democratize society.
Yes.
And I just love this and try to translate this into theoretical and legal terms.
Yeah, this is mid '80s or early '80s, and the article is 1983, and then I still vividly remember when I just graduated from the law school in Prague, and a colleague of mine came from Germany with a photocopy of your book, Law as an Autopoietic System.
You read it in German?
In German,
wow.
In photocopy, and in early 1990. And it was an important theoretical moment, not just for legal theories, but even for social theories, because now you had a sociology of law which was systemic, which was theoretical, and which was social at the same time. And you gradually shifted from Habermas to Luhmann, but your elaboration of Luhmann's concepts, it's quite critical, isn't it? Yeah. If you read the book today, it's a very critical assessment of Luhmann's systems theory, such as hypercycles, semi-closures. There is an element of softness and reflexivity there.
Yeah, I mean, if I just look back at how these things developed in my mind, I think I had several phases. No? I mean, it began with my childhood experience, but then and my idealistic ideas about this Gesamtkunstwerk. But then my first phase was really purely legal doctrine, with all the artificiality, but also with the beauty of this conceptual architecture. But then I moved into this reflexive law phase, where I tried to make fruitful some insights of social theory on different legal rationalities. But then came the phase which I would call the pure theory phase. I was so fascinated by the autopoiesis theory, which was in its beginning at the day, and I was happy in a sense to participate in the development of one theory. It was Luhmann was the great figure, but it was kind of also collective enterprise. Several people were at the same time then trying to develop these ideas. So one should speak of an auto-galaxy and not just of an auto system there. But then, so I moved into pure theory, also kept my distance from Habermas more and more because I found him a bit too idealistic, almost naive. But then I felt also the shortcomings of the pure theory, especially for my project. So, and then in the later stages, I then tried to move back to what I call sociological jurisprudence, which would mean to try to influence law, legal practice, legal doctrine from sociological insights, not only in terms of legal rationality, but also in quite concrete terms. When I was working on, let's say, the doctrine, legal doctrine of networks, as opposed to contracts and organizations.
I think in the book you make it explicit that reflexivity means the possibility to influence legal doctrine and legal decision making. Yeah,
yes.
It's almost an American position.
If you want. But I mean, my distance to Luhmann, I mean, he's the great figure for my life and still is. But let us say, I did not try patricidal movements, like many people do. They just want to kill the great father. My ambition was rather to develop it further. Mm-hmm. And in the book, I think it was Luhmann's great merit was to develop a theory of the autonomy of social systems, right? Autonomy and closure and all that. And rather weak in terms of structural coupling. This was more still not yet well developed. So I thought this is what we have to do now to develop the intersystemic relations. What are the relations between those closed systems? And if they are really closed, then this means their openness must be of a different kind. So I try to theorize about this in the book and also later on. So in a sense, this became my theme. The relations of law to different social fields. And reflexivity plays there a great role, a greater role than Luhmann tends to think. He thinks more in terms of blind evolution, while I think one needs to strengthen the element of reflexivity, which means in law three things. One is self-reflection of law in this situation of being surrounded by all kinds of autonomous or autopoietic systems. Secondly, it means how to further the reflexivity in other social systems by third procedural means. So in these three meanings, reflexivity seems to play a great role in the question: how are the external relations of law to society?
Yeah. For you, if I understand it correctly, closure is a matter of evolution. The legal system has to establish its own closure, and that's why you have these several cyclical movements. Yes. And it's not just normative closure, cognitive openness, like in Luhmann. Yes. If we go back to this the period of early 90s, how was the book received in Germany?
I must say the international reception was more vivid, lively than the German one. In Germany,
this was my second question.
In Germany, it was received, as part of the great debate between the two theories, the critical theory on the one side and Luhmann theory on the other side, and I was positioned there, and it was accepted. But I think the more interesting is the reception elsewhere, and of course the European University Institute had, and my socialization there had an influence, because I was day to day exposed to people like you from Czechia and other people, and so you just develop this kind of translatability.
Okay, so transnationalism came at the European University Institute in Florence. So it was important for your theory formation.
Also global law. I mean, we experienced there how this works. I mean, of course, the institute, a small thing, but there were these treaties. It had a constitution. Huh?
Yes,
It had a constitution. These treaties between the countries. But the rest was us. So we made our law, right? So we developed a kind of academic law of procedures, of, for example, very funny things. Secrecy in doctoral exams, yes or no? The Brits said, I mean, these corrupt Europeans. They do this publicly, and they make a kind of show, and they don't make real critical arguments, while the Europeans said, well, these Brits, they're corrupt. I mean, what are they doing in their closed chambers?
So structural corruption.
and the result was a kind of compromise between the two things, right?
Okay.
So, for example, it was open, public. Everybody could speak up. This is the good democratic tradition.
Yeah.
But on the other side, the doctor, father, and mother were not allowed.
Yes.
They were in a sense, they were on the side of the defense.
Yes.
So I think there.
So you have an early example of regime collision, and
very good.
Okay,
very good.
and Gunther theorizing while working at EUI.
Quite right.
So the EUI community, when you go back today, it's almost the mythical period of people like Gunther Teubner, Christian Jürges, Joseph Weiler, and Neil Walker, and
Karl-Heinz Ladeur,
Karl-Heinz, and others. So the idea of law as an autopoietic system coincided with your development of theory of global legal pluralism.
I think one could say this. The EUI experience was a kind of the initial moment for doing that. Yes. And I mean, about the reception of the book, I think this is still interesting how different in different national cultures this was received. I mean, England and the United States, although it was received, let's say, with curiosity. What are these European people doing there? Strange stuff. Right? But it was always met with curiosity and politeness, of course, but also skepticism. While in Southern Europe, Italy, Spain, also in South America and Middle America, it was received, I must say, enthusiastically. My explanation is it has to do with individualism. The strong adherence of the English and the Americans to the acting individual and nothing else. Everything that was beyond it is mere metaphysics. While the Southern cultures with Catholicism, the Church, and the Holy Spirit, they are used to think also philosophical and legal in terms of super or ultra-human experiences and processes, anonymous processes which cannot be reduced to individual action. And in a sense, system theory has this element with the social systems as kind of anonymous processes that cannot be reduced to actors. So.
Beyond theory of social action into theory of social systems, and beyond anthropocentrism and
quite right.
So it's and of course in Britain it was introduced by people such as Zen Bankovsky and his
who made together with wife a great translation, very linguistically very fine done.
And the book was published. The English translation was published quite early, 1993. So so it was also a result of working in an English-speaking environment in Florence.
Quite right. Yes.
So the period of the 1990s, and all of a sudden, even in British socio-legal studies, you have this return of theory, return of legal theory, general theory. Yeah. And what pushed you further into this theory of global law and global legal pluralism was first your elaboration of the notion of paradox, and how you made it very clear in the 90s that paradoxes don't stifle discussion. Let's proceduralize them, let's deparadoxify. So law is a matter of process.
Good point. Yeah, I mean, I think the paradox is absolutely central to this whole theoretical enterprise. Yes. And I think here's a misunderstanding involved, because people tend to see system theory as something systematic, clear, well-ordered, even crystalline, structure, processes, code. Every system has, its own characteristic, a well-ordered German concept, theory. Yes. But they forget the wild and irrational elements in this whole theory, right? Mm-hmm. And the paradox is, in a sense, the bridge between the two. And it's not just that one says, okay, like in Nietzsche, Dionysian and Apollinian elements. No, there's a strong and almost necessary connection between the crystalline world of systems and the wild world of chaos, irrationality, horror. Yes. And this is the very paradox, is the kind of turning point. And the necessity is created by historical developments, namely the rise of modernity is starting with the Renaissance, the autonomy of art, of science, of law, of the economy against the church and politics, so also the autonomy of politics, right? And this autonomy is created by formalization, and formalization is the application of the medium to itself, so power to power, money to money, law to law, secondary rules and all that. And this is self-reference. Yeah. So the autonomy has to do with the self-reference, creating social systems of their own. And the point then is that once you speak about self-reference, you are constrained to deal with the paradoxes of self-references. And they are paralyzing you if you have no way to overcome them. So there is then the chaos, the social chaos, and here's the paradoxes. And the social chaos is always threatening via the paradoxes, those wonderful words of the system. But it's not only this kind of conservative ideas that the cultural world is always threatened by wild things. No, the point is, as you mentioned, is that the paradoxes have a creative power. That the paradoxes, in a sense, are the provocation to renewal, innovation, thinking things new through in all this. So there's a kind of rhythmical movement between deparadoxification, creating social structures in their self-referential way, and at the same time, via social change, the renewal of the paradox, the comeback of the paradox, and then again a new attempt to deparadoxify. And you can see this in law with modernity. The legal paradox is what we call the Münchhausen trilemma. So the way how the law, as autonomous law, has big legitimation problems. How can you legitimate your norms? You either do this via regressus ad infinitum, one norm after the other, or you do this via rupture, like Kant, or you do this via circularity, right? Yeah. And here's the paradox and how to overcome it. And there were several attempts in the past, and the state law, in a sense, has this problem that what is at the root of the state law? Violence, right? Violence, paradox. Derrida says this, Luhmann says this, right? But the state law has overcome this, or has dealt or coped with this for centuries, or we could say it has tranquilized the paradox. But now with globalization, the problem starts anew, because those different global villages, right, they create a law of their own without any legitimation, without any roots. So there the paradox suddenly is there again. Yeah. Is it legal or illegal to apply the legal distinction there, right? Yeah. So they have to deal with a paradox, and we then observe, and we have to participate even in this process of deparadoxifying the paradox of global law. And this is done either by temporalization, by hierarchization, externalization, or, and here comes then my point of my end of my life, constitutionalization. So yes. Constitutionalization of these new types of global law, which are distant from the state in their legitimation problem, need, in a sense, a kind of constitutional foundation. And here's the very dynamics.
We're gonna talk about societal constitutions, but I still would like to keep you in your 1990s, yeah, because
okay.
There's a shift from yes. Teubner talking about Habermas, Luhmann, moving to Luhmann, but then the 90s, yes, it's this shift towards paradoxes of law, which become almost naked and visible in global domain, but also to regime collisions, and you became much more involved, and you started using a lot more Derrida, Lyotard, and postmodernists. It's almost like using postmodernism without becoming postmodern, yeah, because you never have given up to the task of general theory and ground yes. theory. Yes. And with this global law and the regime collisions, It is globalization of what used to be referred to as private domain or private law. So constitutionalization and private law sounds like paradox within the legal doctrine, doesn't it?
Yes. Okay, postmodernism and all that. Yeah, I mean, this was, of course, also the very lively debate in London. We had this London theory group, and there we were, German
This was after you finished EUI?
Yes, yes.
At
so
EUI,
this was
and you moved to London School
93 to 98 or something. So 5 years, quite lively years in London, where this theory group was quite...
You had Kahn Freund chair in comparative law.
London School of Economics in comparative law and legal sociology.
Yeah.
And quite lively debates. And I mean, my point, similar as earlier, was, I was moving against what I call post-structuralist quietism, right? And I was especially attracted by the late Derrida, who by the Derridians, is almost has become a hate figure, because he was beginning to analyze the different institutions of modern society, one by one, almost in a Luhmannian way, if I may say so.
Yes.
And then his message was so interesting. His message was, again, the paradox, that they're all have a paradoxical foundation in violence, or law, politics, morality, the economy. And now comes the interesting point and the difference to Luhmann, that Derrida is different from... Luhmann says, once we see the paradox, we know, this is terra incognita and forbidden area. So we have to draw back and find new distinctions and go on with our daily work. Well, Derrida says, no, we have to enter. We have to enter in this world of paradoxes, which is a kind of self-transcendence of law, and we have to move into this strange, irrational world of walking through the desert, so the kind of Abraham and Jesus Christ experience. Yes. Right? Yes. Yeah. And I think this, together with Levinas, is a great achievement in the theory of justice, and I try to continue on this way, and also to develop a concept of justice which is no longer a theory of rational argumentation. Of course, it has its important place, but it goes beyond that and goes into the irrational. It goes even into the fields of transcendence. Of course, non-religious transcendence. This is important, not transcendence without God, but the self-transcendence of law in the field of justice. This is, in a way, the kind of liberating experience we need. Yes. And then the point is, of course, also like Derrida does, coming back to the world of legal calculation. And this is what the post-structuralist quietists don't do. And therefore I accuse them. I say, you are not responsible. Yes. You're not responsible. And the responsible thing is to come back to the world of legal calculation, but with the experience of the paradox and the encounter with this strange justice which has no guarantee of being fulfilled. So I think this is something very, very important as a kind of dangerous supplement to the clarity and rationality of the Luhmannian theory.
This is Peter Fitzpatrick, Dangerous Supplements, early 1990s.
If you want, but also Peter, he remains there, in this somewhat vague area.
But this idea of justice as always coming and never there, it's...
but I have my problems. People in a sense falsify Derrida. Yeah. When they temporalize him, when they say, this is avenir, it means a kind of far future which we never reach, and they negate or ignore, consciously almost, the transcendent element in it. That it does not mean just, moving in time and say, it's never reachable, but it means a totally new experience, experiencing transcendence, and this is different, and he says it, and many of the Derrida people just,
And then they make this step back and say, justice is never achievable, but we're working on it.
Which is a trivial idea.
Yeah, which is
and it's much more dramatic. If you say it's more Kierkegaard. Huh? It's more Kierkegaard who's here, right, with this trembling experience of the unknown.
Yes.
Right. So, but we should not misunderstand this as religious. This is always the point. Huh? So law is not religious, and I would argue the Derrida-Luhmann synthesis can be done in this thing that we see the different institutions of modernity with a rationality and normativity of their own, which are exposed to their own paradox and which have to go through the experience of their self-transcendence. And the self-transcendence of law is different from the self-transcendence of religion or of the economy. And then come strange things out that, self-transcendence of the economy, capitalist economy, is the gift.
Yes.
Very good. And politics, friendship, and law, justice. Yes. So I think this is a great theory, and we should really learn from the combination of these two thinkers.
I have to say that I always learn in this respect of experiencing transcendence beyond religion. I always learn from one insurance lawyer who worked in Prague, Franz Kafka, and the great interpretation of Before the Law, the short story. Yes. And it reminds me that I always emphasize to my students and my colleagues that Kafka, when he was reading these stories, he was actually laughing, and he was crying while laughing when he was reading them to the group of his friends and fellow artists. And the introductory chapter of your Law as an Autopoietic System has a story, a rabbinical story about God who is laughing at his people.
Kafka. Post-structuralist quietism, Agamben. How does he interpret the story Before the Law? Huh? He says, it's about the abolition of law, right?
Yes.
And there's Hammacher, a post-structuralist in Germany, very famous. And in a debate, I then asked him, now, what are you doing with this, the light which is coming out of the law itself? And he said, this is just a little lamp. and in this story,
it's a great...
in this story, in spite of all its negative attitude and its despair, we should not forget this very light. And Derrida says this is the most religious element in the whole story, right? When this man is dying, and then so he sees something like justice or something, right? So, and Kafka was also a man who was working on social reforms. He was not just how they try to describe him today, as the man of total negativity. And Agamben is wrong. Agamben is wrong.
I completely agree with you. And I was thinking of Kafka when you said that you have to go back from this experience of transcendence into law as calculation, because he traveled all the way from Prague to North Bohemia to meet workers in textile factories to file their insurance claims, and he was working there. So, and the idea of the castle comes from there. Yeah, it's okay. Let's return from the castle into global chaos, and increasingly you were engaged in this societal constitutions project, and it coincided with your theory of global legal pluralism, and you so successfully managed again to combine and interpret in the most original way several theoretical streams or conceptual streams. Eugen Ehrlich, the long tradition of sociology of law, David Scully, and Niklas Luhmann. So, yeah, turn of the century, new millennium, Teubner of societal constitutions.
I mean, Ehrlich, I think he's very, very important once we globalize him, because what Ehrlich and Schully and also Luhmann have in common is to cut the too close ties between state and law, right? And to see that law has different sources than just state law, which makes then the law growing up from bottom up within society so important as an object of analysis, but also as an object of politics. Right? And Schully, in a sense, added to this law outside the state, the Ehrlich idea, he added to this constitutionalism outside the state. I think this was his great idea of a critical non-Marxist theory, and he used it also in the sense that societal constitutionalism is the main barrier against tendencies of authoritarianism in state and society. So he saw this, what I always call this, the limitative function of constitutionalism so strongly that he said, in the past it has been that, and in the future it will be even more. Right? And I think what I did then to move these ideas on the global level and look at the development of different legal phenomena, and one, of course, is global law beyond the state. And it has to do, of course, with blind social evolution, namely the expansion of functional differentiation away from the nation state toward the world society. And there are now the existence of the new global villages, which in themselves create their own law. Right? But own law as an illegitimate law, as a corrupt law and all that, a law which is in need of its legitimation. And here comes in, the constitutionalization movement, that these laws are in a desperate need of a legitimate foundation, which would be a constitution. And the most important thing is limiting expansive and imperialist tendencies of different global fields, especially the economy.
That's, I think this is the moment when every legal theorist would jump and said, well, but as we know from Godfather, the primary goal of the family is to make the family legitimate, and it never happens. So we have to make the basic distinction between legality and illegality, and by confusing customs and rules, which even criminal gangs have, with official legal rules, sociologists of law like Ehrlich and others basically confuse legal science. What would be your response to it? Because you bring back the legitimation question.
Yes. No, I mean, one is let's say, the question of the definition, what is law, right?
Yes.
If we if we cut the ties from state law and say also there are other phenomena of authentic law within the world, within the social world, how do we distinguish them from customs and all that? So, and here I think we need to autopoeticize Herbert Hart. I think he had this great idea, the definition of law is a union of primary and secondary rules, and we have to processualize it as a union of primary and secondary normation processes. And there we are. If we can identify a phenomenon like this, wherever it happens, it is law, right? Yeah. And even if it's an immoral law, right? And then comes the other question in now about legitimacy and responsiveness and democracy. And these are the constitutional questions and problems which are strong. And so, for example, take the lex sportiva, which is a totally corrupt,
yes, yes, FIFA,
FIFA, totally corrupt business, right? A hierarchy, rules, laws, lawyers, trials, and all that. And here is the problem: how to constitutionalize these private, corrupt regimes.
Isn't corruption a form of constitutionalization? Or if I challenge you, I said, doesn't it take in the end an American prosecutor to challenge these constitutions, corrupt constitutions of Lex Sportiva?
I mean, I would say this is the question: what is the role of the states in this process? I mean, according to my view, constitutionalization is an internal matter. Yeah. Otherwise, we would speak of regulation or something, right? But if we speak of constitutionalization, which means to change radically the internal structure of an organization or regime, right? Change it internally. But then comes the question, this will never happen, as you said, within these, upon the initiatives of those corrupt regimes themselves. They will self-protect themselves. Yeah. So, right. But here comes then the important question of the unity of constitutionalization and external pressures. And I think here we must really sing a laudable song for the protest movements, for the social movement, for the NGOs, who were, the forces that made scandals public, created pressures and all that. But it doesn't help alone. And here the states come in, hopefully, they come with political pressures and political initiatives, like the American prosecutor, right, to make pressure upon those corrupt regimes to create the rule of law, to make good procedures, and even to democratize themselves. Right? So I think this is a parallel. I mean, we should never forget, we tend to glorify public law and the state for its rule of law and democracy and all that, but we shouldn't forget, first, its long history until, the corrupt political repressive regimes became transformed into constitutional structures. And secondly, look at the world today, right? So where the little minority of states has good rule of law and democratic structures, right? So it's a kind of ridiculous comparison to say, look, public law, public constitution, states, this is the good order as opposed to the corrupt private regimes. It's just ridiculous to argue like this. It confuses the ideal version of the state with the real version of the economy instead of comparing the ideal version of the one or the other and the corrupt version of the one or the other.
Yeah, right? Yeah, absolutely. Don't overestimate the role of the rule of law. And I think this is your whole
cannot be overestimated.
This whole theory of constitutionalism, and you actually contributed so much to the field of sociology of constitution, sociology of constitutionalism, which is a very rich socio-legal field today. And at the same time, what I said in the beginning of our conversation, you removed the concept of constitution from the juridical domain. So you made it almost a social theory, social science concept, which is elastic.
You know what the constitutional lawyers tell me? Gunther, you are stealing our public law concept and are misusing them in the private and social context.
You're corrupting them. No.
Stealing.
But I know constitutional theorists who have the highest admiration for this step, because it is actually important for self-description of global law and for self-description of law, constitutional law as constitutional pluralism. And you have in your book Constitutional Fragments, published in 2012, you make this bold statement that we have to remove constitutions first from nation states, then from institutionalized politics, and then from power itself.
Yes, sir. You are under accusation.
Yes, and I want to ask you, because then you make several conceptual distinctions which are very original, which work amazingly in your book, yet which are controversial. First difference, le politique, la politique. So, if it's politics without power, what defines this politics?
Well, it is not politics without power, because we have to distinguish power in different contexts. Mm-hmm. The main context in modern societies where power is created, administrated, and all that is what we call the political system. So the institutionalized form of voting, parliamentarism, government, and all that, public law, right? So this is the administration of power, hopefully with an orientation toward the common good, hopefully I say, right? And then we have phenomena of power everywhere in society. So one always accuses me of not seeing them, but I see them all the time, right? So there is economic power, there is power in the academic process. So power is an ubiquitous phenomenon, and it is not just Foucault who discovered that, but he did it in a very, how shall I say, expressive way. How even the most humanistic disciplines and practices like medicine and psychology, how they are creating micro power structures and repression of the nation, all that. So it's not the case. It's not the case that the power phenomenon is ignored, and it's not politics without power. So what I'm arguing for is an internal politicization of different fields of society, which in a sense is one of the driving forces toward their constitutionalization. So this is one thing. Political discussion, debate, antagonistic conflicts are there within the different social systems, and I tend to call this reflection politics in order to keep this apart from the power administration of the political system, right? And constitutions have as one of their first roles to play in their limitation of power, be it in the political system, human rights, separation of power and all that, right? The rule of law as a means to, which is very strange, that the power process itself limits itself via power, something paradoxical. And my argument is similar things are developing and will have to be pushed in different fields. Fighting economic power, for example, is one of the main things. Yeah. So, but also fighting the power of technology. And now comes the point, which is for me so important. We cannot limit the attention of constitutionalism to the power phenomenon. This is what most people are doing, and also I think people who are working quite parallel and closely with me, they tend to reduce the constitutional problem, be it in the state or be it in different social fields, to the problem of power over there. And I think this is true to a degree, but limited, and they do not see the other side of it. So let's take the economy. So what is the constitutional danger of economic processes? It is their imperialism into different social fields, the commercialization of every field. And how does it happen? Via power? Do the corporations march in, or do they exert their organizational power? No, it is seduction. The seduction by money, right? Yeah. So the scientists, you and me, we are just bought off. We are seduced by not by economic power. We see this, but it's not our problem at the moment, right? But the problem is the money mechanisms, the seductive elements in it, which needs constitutional domestication, right?
So it's not the institution, it's the medium which is causing seduction.
Yes, and this is, I think, where several, even of the societal constitutionalists are too limited, because they only see power and they don't see that, for example, I gave the example of the seductive elements in the economy, but think of technology, think of Fukushima. Yes. This is not just a question of economic power, but still it's a constitutional problem. Or think of medicine, of all the new techniques. Yes. To deal with them is not just a regulation question. I mean, it's the constitutional question of science.
But now you talk about the constitutionalization as limitation of external expansions of other systems into other social fields. But you mention this capillary power concept, and of course it's Foucault's notion, and he makes it clear that law is unimportant, power is productive, it's all about societal norms. So to what extent this notion of the power of social norm is fitting into the concept of societal constitutions, because then constitutions are not only limiting, they are expansive, and they produce power within themselves. So
I very much agree. I was talking about this limiting thing, which I think is the pressing problem today.
Yes.
But at the same time, we have what I call the constitutive element in constitutions. So like in chess, there are the constitutive rules which create the whole game of chess, right? And without them, they wouldn't exist. So this is one of the most important roles of constitutive rules, to create, to invent, to artificially build, to create out of nothing new social norms, which then exert their influence, power, if you want to say, on us. So I think this is, let's say, the primary role of constitution, and not only of the power constitution of the state, but also how to create money, which is an artificial creation created by constitutive norms, and how to create the epistemic construction in science. All these are, I would say, created by constitutive norms, which also then create, as a kind of side effects, the famous Foucault effect of the micropower. But Foucault, his problem is he has an conflationary concept of power. Everything then turns into power, and I find this a bit ridiculous for an analytical mind who should have the responsibility to make more fine distinction between what is power as we experience this in the political systems or in economic power, and then other types of influence, for example, seduction, or the power of the Habermasian discourse, right? The power of truth.
Yes.
So I think here Foucault is guilty of the sloppy
or a Nietzschean twist and seeing power everywhere. And
quite right. And so, on the other hand, if we make such a wide power concept, then of course many of my distinction of the different media would be covered.
Yes.
So in this sense, I would say, okay, consensus, but I think we have a kind of responsibility of, when understanding the different mechanisms of social influence, right? And not just reduce it to the power, especially when we are interested in counter mechanisms, counter power. And here again, I must criticize my friends that they are obsessed with the power phenomenon, right? And then they can only describe resistance against economic power in power terms, and they can. And I mean, look at academia. I mean, isn't it ridiculous Bourdieu is really the sinner. I mean, he learned from Max Weber about the differentiation of society, has this different champs, the different camps, but that with its own normativity and own structures, but then says, but all these different social camps and with their social capital, their mechanisms are only used for the power fight of the actors within. I mean, can you explain to me the development of theories, just by the power fights of the professors?
Yes. And I liked your comment on how you create money, and it immediately, because we are coming to the final questions of our conversation, although I would like more and more, but you say how you create money, how do you create credit? This is the current situation of the European Union. In your book on societal constitutions, or constitutional fragments, that constitutionalization is also fragmentation, and you distinguish between functional differentiation and segmentary differentiation, how to protect cultural diversity. You make a bold normative statement there. But I would like to ask you something else. For your European integration, so differentiation integration, Europe as such, which creates its own credit, artificial things like credit, science, and solidarity. We know there's never enough solidarity. And
Yes.
can you create Europe by solidarity principle? For you, this whole project, is it a part of almost a dated project of recreating statehood at supranational level? Or is Europe an avant-garde, or rather an example of functionally differentiated society which doesn't need states?
Yeah, I mean, as I observe it, the European project has been on this track of recreating nation-state structures, and we see also the limits today. I mean, my idea of Europe is historically seen the following. There is something about the unicity of Europe. And the unicity of Europe in its history, I would say from the Renaissance on, is what I would call a double plurality. The first plurality is well known. This is the plurality of, in this little geographical space, so many national cultures, languages, and all that. So we know that. Nothing special about this. But the interesting thing is that orthogonal to this national cultural pluralism, we have this pluralism which we call functional differentiation. The autonomy of art, the autonomy of economy, of law, and also different, shall we call it, Mannheim called this cultural provinces. Yes. So we have on the one side the national provinces, and on the other side the cultural provinces. And the point is the crossing of the two, and the combination of the two. So historically, the European project is not a project of Christianity, not a project of values. All this is nonsense. The project is the combination of these two societal principles, national and this kind of, how shall we, functional plurality. And you can see in the history of Europe, you can see temporally and spatially certain high achievements, which are then imitated by the other nations, reformed, reflected back, and all this. So Italy in the Renaissance time, art, which was imitated in France, in Germany, and everywhere, and then went back. But after 200 years, it was more or less over. Look to France, Louis XIV. Louis XIV, the power, yes, the absolute power, which was imitated everywhere, and so on. Look to Britain, capitalism, right? Which was the great achievement there, and which was copied, imitated, but also ended up in the varieties of capitalism. The social state has nothing very much to do with the British elements. And look at Germany, they would say it was science, but only for 100, 200 years, right? And then it's over. Yeah. So this kind of dynamics is, I think, specific to the European experience, and there should be our attention. I mean, today this whole thing has expanded over the world, both pluralism. So it's no longer unique European, but it is the project of modernity, going over the globe. And Europe still has a message, because this message is in a sense perverted if you look to the United States. I exaggerate, I would call it economic totalitarianism. Right? It's perverted in China. Also the new China, which made good moves toward the autonomy of the economy, but the rest is under the repression of the political party, and so on, in Russia. So still Europe has a role to play also for this intricate and delicate balance of these two processes. So this is where I see my Europe and its richness in this double sense. And in terms of institutional project, I would be careful with the superstate. I mean, of course, it needs some centralized things. No doubt the problems are wide, but in a sense, to go on with this very structure, it needs more network-like structures, cooperation, perhaps different speeds and all that. So I'm a bit skeptical toward the superstate. But and I would see, Shall we call this organized pluralism or something?
Okay, okay, organized pluralism. Gunther Teubner, a great European, global scholar, and social theorist of law. Thank you very much for coming to Cardiff and for this conversation. Thank you.
Thank you.